Legally Speaking with me, Tarun Nangia. Today we take up a very, very interesting case on Saturdays with Singhvi, namely the recent bail was about the promoters of M3M, which is Pankaj Bansal and Basant Bansal, which in a sense laid down very important points of law, which Dr. Singhvi, our guest today, had in a sense argued before the court. But first, let me introduce you, my guest. As for the older viewers of Saturdays with Singhvi, you all know who he is. Anyways, a lot of people know who he is, but formally, let me introduce him. Third-time sitting member of Parliament, eminent jurist. He has served as the Additional Solicitor General of India. He is also was served as the chairman of Standing Committee on Home Affairs. Because this case today is about the Prevention of Money Laundering Act, there's a big list of people that he defended. There are many, but a few that I would like to name. In the Vijay Madan Lal Chaudhary case, he argued D.K. Shiv Kumar, the Congress leader from Karnataka, who's now, of course, holding the Deputy Chief Minister's chair there. Then P. Chidambaram, he argued for. Karthik Chidambaram, he argued for. Raj Singh Gehlot of the Ambience Group, Dr. Singhvi argued for. Supertech promoter R.K. Arora, he represented. Neeraj Singhal, of course, of the Bhushan Steel fame, is whom Dr. Singhvi represented and argued for. Of course, most recent being, as I mentioned earlier, Pankaj Bansal, Basant Bansal, when Dr. Singhvi assisted in laying down very significant and liberalizing parameters for a law like PMLA. Very difficult to get bail. But how this order will now be cited in many cases across the country, and many people being prosecuted under this draconian law will get relief. We will discuss all of this and more today. Welcome to Saturdays with Singhvi. Good to see you, sir.
Thank you, Tarun, for a most generous introduction. Thank you.
And at the outset, if you could first explain why this case in particular has laid down so many important and liberalizing parameters. What were the arguments? Of course, a lot of people would like to know, how did this happen?
Well, Tarun, this case is definitely of seminal importance, and also because it, I think, creates permanent safeguards, a fence of safeguards which was sorely needed in something which is universally considered draconian and has been made even more draconian than its text by its very, very arbitrary and harsh misuse. So let me summarize, first of all, as far as judgment is concerned. It's a very straightforward, bold, categoric judgment, no ambiguities, no beating around the bush, no equivocation. Now, why it is important first and foremost is, Tarun, because we've had all these cases you cited, many others. Many of them, not all of them, many of them have the issue that you, as an accused, have not been given the grounds of arrest. What used to happen is in almost every other case, and were it not tragic for the persons involved, I would almost consider it humorous or comic. The ED was saying, one case, I picked up Tarun Nangia from his house and I told him his grounds of arrest. In another case, I went to XYZ while I was putting him in the car. I gave him the grounds of arrest. I joked while arguing it. I said, they may even say that he was going to the washroom and we told him the grounds of arrest. Then they took further bizarre pleas. In many of these actual pleas in cases, in writing, in pleading, it's not my imagination. Oh, we did not give written grounds of arrest to Mr. Nangia, but when we filed a remand application in the court, which is after arrest, as you know, 24 hours you have a remand and all that. At that time, our remand application may be treated as grounds of arrest. And so on and so forth. I've given you 4 or 5 different formulations. Another formulation was, we told them and then later on the family member signed because we gave them. Now, the point of the whole matter, Tarun, is that these grounds of arrest are not some kind of a cookbook recipe. It is not just some kind of a formality. It is not giving you a photocopy of a constitution. The whole purpose is that you are informed specifically of how the arrest in that case is based upon your conduct, how you, why you, in what manner you, not generally anybody, is liable to be arrested. And the second step flowing from that is that becomes your basis of briefing your lawyers, of applying your mind, of challenging the detention, of going to court, of arguing your case. So it's a very important bedrock, the grounds of arrest. Now, I don't understand for the life of me that since the PMLA, this current crusade has started for the last almost a decade, not once have they attempted to sanitize their protocol, their procedure. Not once have they said that, look, very simple. After all, you are the arresting officer. I'm the accused. You're only giving me a piece of paper. Nothing is happening, which is going to impede your entire case. What is happening? But they will not give you. They will never say that they are giving you. They will never concede that they're giving you. They will never admit that, so what? We'll give it to you anyway. So this judgment, first and foremost, has now categorically said that grounds of arrest means simply the document with reasoned grounds handed over to you, not merely told to you orally while you're going to the washroom or the car van. And it's not the signing by a family member or you which is important. It is you having written grounds of arrest, because you're not supposed to be a Nobel Prize winner who orally told the grounds, will remember every ground and then brief your lawyers. That's the first seminal part. In this process, it has overruled some judgments or said that they are not to be followed because they don't represent the law. It has made clear that this is a valuable safeguard of arrest. It is a valuable safeguard of liberty. It has made clear that this is the way the law will be. And I think that is the heart of the matter. Senthil Balaji, which it has cited, no doubt, had more stray, more casual passages on this. It was not so directly on point. It was more by implication. This has solidified the law. It has developed the law. And the second very important point, then perhaps I can then stop there because I've taken some time on the first point because it's a very vital point. But the second important point, Tarun, has been in this judgment, a reiteration. What is unfortunately happening is we give long seminar lectures, long talks on Article 20 and 21 of our Constitution, the sentinels of liberty, the right against self-incrimination. You cannot force me to say, I confess, please leave me. Yes, I'm guilty. I did so. Suppose you ask me a question. Theoretically, it's not done like that. Let me tell you something theoretically as a lawyer. If you as a policeman ask me a question and I say, sorry, I don't want to answer. Sorry. Or I can say a series of I don't know. I can't recollect. Or I can say, I will not answer this question. Can you, as a police officer, force me to answer the question as a question, simple question I'm asking? It's obvious even to a layman you cannot. It's the right against self-incrimination. You can prosecute me, you can get corroborative material to show that I did this, you can convict me, but you can't say, look, because you said so, Mr. Singhvi, I'm arresting you because you are non-cooperative. Non-cooperation, this delightful phrase, now used in every other case I find, has become a methodology of self-incrimination. Non-cooperation means what? I mean, I'm accused, I don't want to say something. I have a right not to say it. You have proved it otherwise. But now, every arrest memo I find, 90% cases, Tarun, I find there is non-cooperation by Mr. Nangia, therefore I arrest. So this is the second, and this, mind you, is not an invention of this Bansal's case. This has been held way back in many cases, the most famous of which is Santosh Kumar or Santosh judgment. That says clearly that non-cooperation is not a ground. He will answer what he likes. He can say, to hell with you, or he'll say, I was not there. You prove it by his call records. So this is the second thing which is very, very clearly. And there's a third thing which I'll tell you on the conduct, which means that even the court has, in a sense, deprecated the way the ED behaves. So conduct could come up for scrutiny in later cases if the ED continues to be arbitrary.
Now, very importantly, for the lay businessman, many of whom are facing or being prosecuted under the Prevention of Money Laundering Act, does this order mean that whenever they are arrested, written grounds of arrest as a matter of right shall be given to them so that they could inform their lawyer and guess the best legal advice?
Absolutely. That is an unequivocal yes to your categorical question. And if you don't do it, it's at your own peril. As a matter of fact, I'm amused to note that within 72 hours or 48 hours of the judgment, there was two more arrests and cases. And those people duly, in one of the political case, which I am handling for that particular group of political entity, and this is an individual, of course. And it was very amusing to find that the first thing they did, two interesting things. They changed their protocol in 48 hours. They gave written grounds of arrest to at least obviate this particular challenge. And they did not put their non-cooperation.
So I want to ask you this because this gets very interesting.
Want to learn, it's not that there's lack of learning. They fully understand it, but they were deliberately not doing it out of obstinacy.
So until the Supreme Court said it, they were not doing it. I want to know from you this, that supplying written grounds of arrest means that the enforcement directorates walks into your house, office, or wherever they choose to arrest you. They hand you over this copy that, Mr. So-and-so, this is the ground on which we are arresting you. You have a right to legal counsel. You can call up your lawyer and get advice. Because in the end, once you're incarcerated, of course, you have right to legal remedy. But how do you go about accessing it? Is the accused and the family members who are handed out this document? Because this is new for most businessmen. Prosecutions were less earlier, so people are not acquainted really.
So Tarun, first and foremost, to have a document which gives you grounds is a very big bulwark. It says, I, Abhishek Singhvi, want to arrest or am arresting Tarun Nangia for the following reasons. Now, it is not that you are going to go to a law state. You're being arrested and taken away, but your family will be having that paper. They will know the grounds. Secondly, the grounds naturally is a very important point is it connects, it is specific to Tarun Nangia. It is not that I arrest you because you have violated the provision of the PMLA. It says specifically because Tarun Nangia did this in this manner, etc. Or I believe that Tarun Nangia did this, or this is the proceeds of crime, or this is the sequence, blah, blah, blah. Thirdly, there's a very important third purpose. One purpose is, of course, accused-centric. The accused can consult his lawyer, his family member can go, and they will focus on those reasons. The third is that this shows the application of mind. I can't, as a PMLA officer, sit in the comfort of my sofa and just think of something and say, okay, I'm arresting you. I have to apply my mind because I have to give that application of mind meaning and content. And fourthly, the application of mind has to be reflected in reasons. These are extremely important facets. They are the connecting links. And it can't be anybody's casual whim and caprice. It forces you to apply your mind. It forces you to give reasons. It makes it more substantive. And of course, the challenge becomes easier.
Now, one thing that all businessmen or accused would also want to know, people who are defending themselves, is this statement, which is grounds of arrest, equal to the enforcement case information report, abbreviated as ECIR?
No, that's utter confusion, actually. I'm glad you asked that question. See, the ECIR, there is a paragraph in the old Vijay Madan Lal Chaudhary which says it need not be given. That was one of the confusions created by the ED. The ED argued in this whole series of cases after Madan Lal until now that, look, the fact that I'm not required to give an ECIR to Mr. Singh means that equally following from that, based upon that, deriving from that, if I don't have to give you the ECIR, I also don't have to give you grounds of arrest. This is the utter fallacy which I'm telling you just now. This is the fallacy which they also relied upon and created. There are many cases where they've argued that. Now today that has been debunked. And ECIR is nothing obviously in different parlance, but in substance, akin to an FIR. It's an information. It's an information which you lodge and register in your records. That, look, I believe I must have further investigation of Mr. Nangia. It has nothing to do with the subsequent physical act of arrest. I may have 20 ECIRs. I may choose not to arrest you. Arrest is a totally different thing. I may choose to just investigate, or I may not have enough material. It is the beginning of the investigation versus the culmination in an arrest. The fact that you don't have to give the beginning has no nexus with the fact that you have to supply the grounds on which finally that culmination is happening on the basis of which you are arresting me. So this confusion is also debunked now. Today, the ground of arrest is that I've had an ECR long ago, I've investigated it, I've inquired into it, I've got this material. Now I arrest for the following reasons. And let me add one more thing, the conduct I talked about. In the Bansal case, for the first time, the court has deprecated the ground. I don't think that's the ground on which he's been released. I don't think that's the ground on which you can say the heart of the ratio of the Bansal case operates. I'm not saying that. But there are important passages which deprecate the conduct of the ED. And I am sure it will act as a bulwark, as a warning against egregious action in the future. What happened in Bansal, you must know, it was ironically I who had argued that virtually in the holidays during a vacation port when I was abroad virtually. We argued successfully and got them anticipatory bail before a learned single judge of the Delhi High Court. I don't know the exact date. I think it was 6th, 7th or 8th of June or some such date in the second week of June of this year. And after detailed arguments heavily opposed by the ED Council, we got the bail. Now, during that entire argument, in fact, spread over 2 days or different days, the ED never whispered that a separate complaint or a separate ECIR 2 months earlier in April was already lying and pending against the same Bansals for alleged bribery of a special judge in Panchkula. We are not on the merits of the case. I'm giving you the conduct. Nobody whispered, nobody opened his mouth, nobody told the judge before whom I'm arguing, who then ultimately grants anticipatory bail. So he says, thou shalt not arrest Mr. Bansal. You go out of court, before the ink is dry on that order, I think in a day or two, they issue fresh summons. And on the first day when you go pursuant to summons, see, look, you got anticipatory bail today. You are reasonably trusting, think, look, I'm free now, I'm protected, but of course I'll cooperate. You go out of the courtroom, 2 days later you get a summons. You say very well, I'm obliged, I'm a citizen, I'm a responsible citizen, I'll cooperate with them. You land up at their office. On the same day, the first day of summons, they call you, they discuss with you, question you, arrest you. On what? On something which is pending 2.5 months before. Now, the judge is not saying that you cannot arrest. You arrest is a different offense. But you did not whisper about this pending thing. You did not tell the judge that, look, sir, you are granting this, at least make it clear that we have full liberty to arrest in any other offense. You did not tell the judge, look, there is another offense pending against Mr. Nangia, which is 2 months old. I'm going to issue summons. Summons was issued, I think, 2 days after Mr. Nangia got anticipatory bail. And I may arrest him. So this is not a reason for the judgment of Bansal, no doubt. It is not a ratio. But I think it's an important warning on the conduct, like a hide-and-seek game, like a cloak and dagger game. That is not the object. It can be possibly the stand of an accused who is entitled to every break he has in law. But it can't be the stand of a statutory body who's supposed to be not a persecutor, but a prosecutor. A prosecutor has to be fair, balanced. You can't play ducks and drakes. Tell the court half, don't tell the court half. Get order in one case, lose the case in one case, go out of the courtroom, issue summons in another immediately, and then just merely arrest him in the first day.
The dilemma of the advocate representing his client in PMLA cases before the court was, he did not have a copy of the enforcement case information report, so he couldn't argue on what point should he argue for his client to get relief. Now, thanks to this case, he has a copy of the grounds of arrest. So if the grounds of arrest appear flimsy, dodgy, or non-reliable, or not grave enough to merit an arrest, if the court in its wisdom so finds, then despite the twin conditions of Section 45, does bail become much easier now?
Well, first and foremost, non-supply of grounds of arrest becomes fatal. It is not bail, but it actually is release from arrest because the arrest is illegal.
Okay.
To be a little technical,
yes,
it's not technically bail. It need not be technically bail. It is the same as bail, of course. There's no difference. Because I am releasing you because your initial arrest is illegal. Okay. If your arrest is illegal, you're not under arrest. If you're not under arrest, the result is the same. You're a free man, which amounts to the same as getting bail, but technically need not be bail, number one. Number two, I hope you've noticed the other distinction. Your very valid point about non-supply of ECR. That now pales into insignificance. Look at the irony. In the ECR non-supply, you don't know even the information against you. Information means why you initiated. An FIR is supplied routinely. It's found easily. It can be obtained. ECR is not. But here the law was even more absurd. Having not got the ECR, you investigate the ECR for 1 day, 10 days, 100 days, 1 year. You then arrest me at that stage also you don't give the grounds. So you have neither the initiation nor the culmination. What do you challenge? What you have said just now is absolutely right, but it's an understatement. That poor lawyer who's arguing in the primary court, we of course argue in the High Court and Supreme Court, which are more appellate. The poor chap who's arguing in the primary ground is shooting in the dark. He's neither got the ECR nor the grounds of arrest.
But
so
for example,
let me tell you one more thing, Tarun. I am very clearly of the view that Vijay Madan Lal Chaudhary in holding that it is the ECR not required to be supplied is wrong. But today we are respecting it because it's the law of the land. It is under consideration. It is under consideration. It is under review. It is under reconsideration. It will live for another day, and that is to be seen what happens in that. But my personal view as a lawyer is that itself was wrong. But on top of that, not having grounds of arrest made you completely, literally with the blind and accused with the blindfold.
Thanks to the order in case of what you argued is Basant Bansal case, if grounds of arrest are supplied and they are non-reliable, flimsy, then does he get automatic bail? Is it just automatic that the grounds of arrest appear to be non-reliable after the court examines it to be so?
No. That's a different point. We were talking of non-supply of grounds of arrest.
Yes, but this is now
After supply, the court examines and says, look, these grounds of arrest are completely wrong, etc. That will be in an individual case depending on the facts of that case.
So the rigors of two condition apply?
No, then of course then you can get bail. Despite now you've come to a different topic. What you're saying is that the section 45 can it lead to bail? Of course it can. High courts have been robust after Madan Lal Chaudhary. After Vijay Madan Lal Chaudhary, which again I think is completely wrong on that point, but I'm accepting it as a law. Nikesh case, which it overruled, was the right judgment. But leave that aside. After Vijay Madan Lal Chaudhary, several people have got bail from high courts because it has been interpreted to say it's not an absolute bar, that section. The section is not a bar to bail. Two, that the judge, when it says not guilty, it doesn't mean that the judge is to give a final verdict of not guilty, because that would be an absurd interpretation. It would mean at the bail stage, I have to give finally a verdict that virtually that Tarun Nangia is acquitted. It has been interpreted to mean that it means that broadly and prima facie, the judge has to see the merits and then come to a conclusion that if he's prima facie not guilty, unlikely to be guilty, unlikely to be convicted, he will get bail. So in that sense, there has already been a dilution of 45 in a very reasonable, commonsensical manner. All that Nikesh, Vijay Madan Lal Chaudhary has done is that it has broadly upheld the validity of 45. But fortunately for us, robust, commonsensical judges who have the right balance between liberty and prosecution have been giving bail in several 45 cases.
Okay. So this judgment has, this order, I correct myself, has at least ensured that counsels are better equipped to argue for their client and matters may not escalate to the Supreme Court for bails. Do you see that happening after this order?
I definitely think it gives a fillip. It strengthens the hands of judges who otherwise feel that the overall context and feel of a case, the overall crux of a case requires bail or requires release from arrest, but are inhibited with this whole hawa, if I may use a Hindi word, created about PMLA. This gives them a certain support system. There's a Supreme Court judgment, which is very straightforward and simple. And this is the kind of approach they must have in PMLA cases.
Two comments from you, which I request. Comment number one on the bench that wrote this order. Justice Krishna Iyer was pro bail. In these kind of cases, mostly relied on documentary evidence. You can always restrain an accused from going abroad. Is it necessary to arrest an accused? In light of all those facts, what would you like to comment on the bench in the light of this order, since you've been arguing many such cases?
Look, you've raised a larger issue. According to me, this whole arrest jurisprudence has been turned on its head. Arrest has become an obligation. Actually, arrest has become now, the moment I have a complaint against you, I must arrest you. That is completely nonsensical. Arrest is actually, you see, you're asking a much larger question. We don't have time. Let me be very quick and brief and point. First and foremost, we function on jurisprudence which says you are presumed to be innocent until proved guilty. Arrest is always at the stage when you've not been convicted, you've not been found guilty. The approach then, according to me, primarily has to be, are you a flight risk? If not a flight risk, are you going to interfere with witnesses? Documentary evidence is hardly liable to be interfered with because there are photocopies, there are all kinds of things. It's very, very unlikely. Third is not flight risk. If you are not going to interfere with witnesses, are you going to cooperate? Will you come to the police station and call? Crux of bail is the satisfaction of these three tests. Now, because you have a special provision about not guilty in Section 45 of PMLA, you can add some merits that broadly on the merits I find sufficient grounds to hold him prima facie not guilty. But in normal jurisprudence, non-PMLA, this should be the only triple test in non-PMLA cases. Unfortunately, in case after case, even in normal jurisprudence, I find judges giving long passages about guilt, about merits. Therefore, this whole, and nobody's trying to justify the narrower issue. Why, without arrest, prosecution cannot be conducted? Why, without arrest, prosecution is thwarted, impeded? That's the test.
One final question before we end. The maximum sentence in the Prevention of Money Laundering Act violation is 7 years. If somebody completes three and a half years, does he get bail as a matter of right?
Again, lack of consistency and equivocal judgments, wishy-washy language are the bane of the system. Okay. Point number one, anyway, less than 7-year cases or 7-year cases, the law is very clear, are to be viewed more lightly, more easily, more liberally for bail. That's one set of established judgments. Second, if you are already under arrest and have served 50%, then there is a direction by many, many judgments that you must be released forthwith. But unfortunately, that's not happening.
Does not happen.
It doesn't happen in every case. I would imagine that now it is happening more and more. There are a series of orders by other benches in the recent past which has given an impetus to this. So what I'm saying is, why should it require an inconsistency? Why should it require a dissonance? It should happen automatically. There is no question of a presumption of guilt or a presumption of innocence operating fairly if after 50% of your time you are still kept as an under trial. We're not talking of post-conviction, we are talking of under trial. In fact, let me tell you that even after primary conviction, if you have served half the sentence, suppose I convict you and I sentence you to 7 years. I'm talking of an extreme example of post-conviction. And your appeal is pending, is the first judgment. The first appeal is pending. Every criminal has a right to at least one substantive appeal. In that appeal it's pending, you've served 3 years already, 3.5 years. Then also you should be entitled despite your conviction. Because you have a substantive appeal pending.
Thank you. Today was a very, very interesting discussion. Most promoters, businessmen, general counsels would find this, in fact, lawyers and judges also, because of course this happened in the Supreme Court, will be viewed by a lot of other people in the fraternity. Today's discussion would be enlightening in that sense. And of course, the order that was passed in Basant Bansal and Pankaj Bansal has, in a sense, liberalized or made an attempt to give liberty its due importance by, as you also shared with us, the grounds of arrest liable to be supplied before the arrest in PMLA cases. Looking forward to another interesting episode of Saturdays with Singhvi soon. But thank you so much for your time, as usual, and explaining in concise, clear points. I'm sure the viewers also enjoyed it. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.